Now, Robin Williams, in his movie Patch Adams, said that, I quote, "A doctor's mission should not be simply to prevent deaths, but to improve the quality of life." But what happens when the rules governing those pursuing medicine are discriminatory and do not reverberate the idea of an improved quality of time? Raking this up, the Supreme Court on Friday came down heavily on the National Medical Commission's guidelines requiring students with specific disabilities to have both hands intact to pursue MBBS, terming them completely antithetical and reeking of ableism. A bench of Justices B.R. Gavai and K.V. Viswanathan deemed the rules discriminatory against persons with disabilities, stating that the rules had no place in a statutory regulation. The bench went on to add that the rules indicate a classification which is overboard and glorifies ableism. Supreme Court's observations come in the light of a committee's findings formed by AIMS to examine the petitioner in question and whether his disability would come in the way of his pursuing medical studies. And to discuss this further, I'm joined by our guest this afternoon, Dr. Sanjeev Bagai, the Chairman and MD, Nephron Clinic. Well, thank you, Mr. Bagai, for taking your time and joining us over here. Mr. Bagai, at the very outset, I would want to ask you, what exactly was the need to come up with a clause like this? Why was the medical fraternity never raised a voice against this particular clause? And now that Supreme Court seems to have put the facts in order, how do you look at the judgment?
Good afternoon. I think the judgment is a move in the correct direction, but I'll put a rider. And very quickly, MBBS or MD or DM or any other postgraduate or undergraduate degree in medicine cannot be compared with any other line. The reason is we are dealing with a human being, a human body, and it's the most enduring 5.5 years medical course of almost more than 19 major subjects and 48 subspecialties. You cannot differentiate between a student who's joining MBBS, whether he wants to do surgical or non-surgical, because that child is going to be rotated amongst all departments in the 5.5 years. There can be no prejudice, correct. There can be no discrimination, correct. All students must be given a fair chance. But if any child who's applying has disability, that child needs to be clinically and psychologically evaluated by a team of doctors, which should include a person in pediatrics or internal medicine, orthopedics, neurologists, clinical psychologists, psychiatrists. The grading of the disability has to be done in a fair manner. If the team of doctors feel that a particular student will not be able to endure the 5.5 years of almost 10 to 15 hours of work every day, then that should be spelled out clearly. The stress, the challenges emotionally, physically, psychologically for a student enduring the 5.5 years medical course cannot be equated with anything else. It's perhaps the most demanding, most challenging a part of a student's life, that is MBBS. But on the same hand, we cannot differentiate, we cannot discriminate. Having said that, there are different types of disabilities. It can be cognitive, developmental, intellectual, mental, physical, sensory, congenital, genetic, chromosomal, and so on. We need the basic faculties with a minimum level of functionality so that the child can complete the MBBS course without any hindrance. But a clinical evaluation must be done, and then a fair call be taken on an individual basis. We cannot generalize disability.
Okay, fair point over there. While you're maintaining that there are areas of concern, there are certain limitations, and this particular profession does have certain restrictions when it comes to the number of hours provided, the physically how sound you are. But when the Supreme Court said, and I'm quoting over here, that one should not assume incompetence without providing ample opportunities after ensuring clinical accommodation and assistive technologies. How many and how do you define ample opportunities over here? Also, the fact that world over, we are going through a technological boom. We have AI at our disposal now. Given that situation, do you feel that these restricted orders and guidelines can have a relook now?
Yes, they can have a relook, but again, I say every particular child who's applying under the category of disability has to be individually evaluated in great depth and detail. There should be no experimentation either with the child psychologically or with the child's career going forward. We cannot allow a child to start MBBS and then fall out or drop out after a couple of years because the person can't cope with the pressures or the physical or the mental or the psychological demands. Having said that, when you are applying for an MBBS seat, the evaluation must be with a comprehensive team of doctors. Having said that, again, let's say, for example, you cannot allow a person who's applying for a job of a pilot as a captain of an Airbus who has visual impairment. Likewise, in medicine, you cannot have a person who has significant amount. I'm using the word significant and it is graded between grade 1, 2, 3, or from 0 to 100 as a percentage. A cumulative percentage of at least minimum less than 40 functional can allow a person to pursue. If a person has significant visual impairment or significant color blindness, that can be a huge issue because you're dealing with human tissue, you're dealing with blood, you're dealing with a person's life. You cannot say, I'm not going to do surgical, therefore I'm pursuing MBBS. That would be a wrong premise to begin with. So there I would tend to differ with the Honorable Supreme Court. We cannot take decisions after a child has joined. The decision must be taken before a child joins MBBS. Very clearly, a detailed clinical evaluation. We cannot blanketly deny anyone, but we cannot blanketly admit everyone with any disability.
So, Mr. Bagai, are you trying to say that the court should try and have a panel of doctors with whom, in consultation perhaps, certain amendments or changes to existing laws need to be brought about? Because a top-down system to say that, yes, it's time to factor in people with different needs, especially abled people, should also be given equal opportunity. There are certain areas of concern and specifics that only those who are in the business can bring to the court's knowledge. Do you feel that there is a need and this step ought to be taken before we arrive at any decision?
I couldn't agree with you more. And being in this profession for more than now 4 decades, in fact, 42 years, I can tell you, and having dealt with children with special needs, with disabilities of different types, of genetic disorders, chromosomal disorders, physical, intellectual, mental disabilities, neurological disorders, chronic kidney ailments, it's a huge task. It is so demanding on a child and the family that you can't experience it unless until you firsthand feel it. The Honorable Supreme Court must institute a panel of doctors in consultation, have a granular level guidelines put in so that then it forms a uniform template pan-India which can be followed across all states. It should include a pediatrician or a physician, an orthopedic surgeon, a neurologist, a clinical psychologist, a psychiatrist, and indeed a person who's non-medical as one person to give a balanced view. So a team of 5 or 6 people, well qualified, who've gone through the drill, who've gone through this entire gamut of qualifications, they would be in a better position to decide whether a particular student fits the need to endure the MBBS course.
Fair point, because there are certain grey areas. You are mentioning about specific concerns, the specific disabilities that may impact the kind of discipline that a given child may want to pursue. Point taken. I would want to also ask you, Mr. Bagai, what about the infrastructure that's already existing in our system? Is the medical infrastructure equipped to accommodate those with disabilities as doctors?
You know, this question is something which is dearest to my heart. Unfortunately, in India, we do not look after I don't like the word disability. I always use the phrase or the term which we call as children or adolescents or adults with special needs or with special ability. I would never call them disabled because that itself is discriminatory. But children or young adults who need special aid or assistance, what we call as people with special needs, none of the offices, corporates, hospitals, colleges, schools are pan-India uniformly equipped to manage these needs. Facilities in schools. Can you imagine how debilitating it is for a child who needs a little bit of assistance? There are not enough ramps. The lifts need to be specifically in order. Guidelines as far as signages are required. I think more sensitization of the entire nation is required, that all people, any child or an adult who has special needs or with special ability, I will still not use the word disability, needs special attention. They do not need to be discriminated, but they need help. They need help from us. I have dealt with children right from birth till the age of 18 to 20 who require these special needs. It's a different ball game. You have to deal with them at different levels, at a family level, at a social welfare level, at a medical level, investigatory level. You need a special heart. You need to reach out to them. But unfortunately, the infrastructure which is at the present moment available needs to be more sensitive towards those needs.
Absolutely, Mr. Bagai. Addressing them as differently abled, perhaps, do you feel that a law amendment can only be brought about in tandem with policy change when it comes to accommodating those with special needs? And that is where the government will have to see that both can only work in tandem. You cannot bring about changes in the law if you do not have the policy or the infrastructure to equip them with.
So there are three parts to it. One is to have a policy as a uniform guideline which the Supreme Court should set in. They have set in a broader guideline, but I would request the Honorable Supreme Court to sit in consultation with the top guys in India, or indeed take views internationally, because all good opinions are good value opinions, and form a guideline so that we can implement it. Second stage is implementation. And third most important is public awareness and sensitization. We cannot be insensitive towards children or young adults who require that special care. But more importantly is, when you are dealing with children, let's say, for example, a Down syndrome or a child with early autism spectrum disorder, the needs are very, very different. So we need a detailed evaluation. I still say we cannot just say a child is 60% or 40% or 20% disabled. We need a more detailed evaluation, and therefore a consultation from the Supreme Court with the medical fraternity would be much in order.
Absolutely. Well, thank you, Mr. Bagai, for putting things into perspective for our viewers over here on this very, very important subject that we are looking at very closely. The Supreme Court ought to have consultations. There needs to be sensitization. There has to be further evaluation before we term anybody as person with special needs. And with that, we're slipping into a short break right now. Lots more lined up. Stay tuned and keep watching Mirror Now.